When people ask if they can beat a DUI, what they really mean is, are there legitimate legal arguments that could change the outcome? The answer is yes, those arguments exist, and California courts hear them regularly. But every case is different, and results vary widely depending on the specific facts. Under the Fourth Amendment in California case law, police must have reasonable suspicion before pulling you over. If the stop was unlawful, a defense attorney can file a motion to suppress, which asks the court to throw out evidence gathered because of that illegal stop. Without that evidence, the prosecution may not be able to move forward. This is one of the most common and consequential arguments in DUI defense. California's breath testing rules fall under Title 17 of the California Code of Regulations. That is the set of rules that governs how officers must maintain and operate breath machines, and how blood samples must be collected and stored. If those rules were not followed, the test result can be challenged. Things like improper machine calibration, failure to observe you for 15 minutes before testing, or mishandled blood samples are all documented, real-world arguments. Vehicle Code 23152 makes it illegal to drive with a blood alcohol level of 0.08% or higher. But BAC rises over time after your last drink, so your level at the time of driving may have actually been lower than the number the test showed later. This is called the rising blood alcohol defense. There are also medical conditions, like GERD or diabetes, that can produce falsely elevated breath readings. Field sobriety tests are standardized, but they are not foolproof. Nerves, fatigue, footwear, uneven pavement, certain medications, or inner ear conditions can all cause a sober person to perform poorly. An attorney can cross-examine the officer about the conditions and how the test was administered, and use that to cast doubt on the officer's observations. Depending on the strength of the arguments, a case might result in a dismissal, a reduction to a lesser charge like wet reckless, or a not guilty verdict at trial. It could also result in a conviction. There is no promised result in any DUI case. What matters is whether the specific facts of your case give rise to defensible arguments, and that is exactly what an attorney reviews during a case analysis. Understanding what defenses actually exist is the first step toward making an informed decision about your case. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.